Good evening and welcome. I don't think this is working. Well, good evening and welcome. My name's Austin Parrish. I'm the dean here at Indiana University Maurer School of Law, and it's my pleasure to welcome you to this year's annual Sherman Minton Moot Court Competition. Sherman Minton was a 1915 graduate of law school. His picture's in the back there, the only one in the room. He was a United States Supreme Court Justice from 1949 till 1956. And this event is one of the highlights of the years. It's one that I look forward to each year. This year, over 115 students participated in the preliminary rounds, starting in August all the way up to now. They competed in more than 6 rounds of competition to make it to this point tonight. Over 200 alumni judged the preliminary rounds. It's a great competition, and the quality of argument you're going to see tonight is going to be spectacular. Before I turn it over to the Chief Justice, who's going to do a number of thank yous, I don't know if everybody realizes just how much work it takes to put on a competition of this size, all the organization. I know Jules is going to thank many people, but at this point, perhaps we could thank all together the Advocacy Board. They've done so much, and this takes so much time. So I have to say, being dean, one of the great things is having the dean title. The only title I'm more jealous of is Chief Justice. Jules Cantor, I'll turn it over to you.
Thanks, Dean Parrish. It's such a privilege to be here tonight and to have served this year as Chief Justice of the Moot Court Board. As you can see by the number of people here in attendance tonight to watch tonight, this is a cornerstone event in our community, and it's just been an incredible year. We took over in May from last year's board, and since then have been working tirelessly to make tonight happen, and it's really, really great to be here with you all, so thanks. This work couldn't have been done without the help of an incredible team that was my exec board this year. From start to finish, they've been just amazing. And I'd like to recognize each of them individually. Some of them are not in the room. They're still doing the job of being on the exec board and are with the judges or the competitors. But when I say your name, I'd love for you to stand and be recognized. And then if you all could hold your applause until the end, that would be great. So our executive judge coordinators were Ben Shoptaw and Megan Van Pelt. Our executive competition coordinators were Allie St. Pierre, Alex Spindler, and Alex Chitwood. Our executive problem coordinators were Austin Andreas and Rebecca Titsworth. Our executive research coordinator was Molly Morgan. And our executive advocacy coordinator was Rachel Laurel. Then our competition board was Morgan Darcy, Dom Denon, Adam Farr, Abby Gorham, Mike Herman, Lauren Jacobson, Trevor Jenkins, Lisa LaFernara, Priya Purohit, and she was our competition board chairperson, Connor Richards, Tyler Salway, Davin Shaw, Brittany Skabowski, Jeff Solar, and Anna Sturgis. Again, thank you guys so much. You made this process seamless. But I would say really tonight is about celebrating the accomplishments of our incredible competitors. I reiterate what Dean Parrish said. This year's appellate arguments were top-notch. I got to judge from the beginning in the practice arguments all the way up until the semifinals, and I was just impressed with A, the improvement that I saw throughout, and B, just the general quality of argument. Our students here are second to none, and this year's 2L class is a testament to that, so thank you guys. And I'm going to go ahead and announce each of you guys in order of accomplishment. So for the Octave Finalists, we had Austin Brady, Christina Correa, Cassie DeVore, Glenda Garcia, Mark Gradanis, Mackenzie Hutchinson, Gustavo Jimenez, Masha Kazakova, Tiffany Kim, Hannah Miller, Ashley Moore, Jake Overlander, Carter Robison, Jen Smith, Rachel Stopczynski, and Kylie Wood. Our quarterfinalists were Mason Clark, Ty Edwards, Taylor Fontan, Jeff Isles, Sarah Lodi, Zach Miller, Caleb Omer, Elmer Thorson. Our semifinalists were Julie Ardelian, Bailey Anstead, Michelle Bartley, and Darian Smith. And then the finalists tonight that you'll be hearing from are Carolyn Haney, Kira Murphy, Mary Pat Stemnock, and Alex Van Dyke. Let's have a round of applause. And finally, I'd just like to recognize the efforts of a particular faculty member. Seth Lawn is our faculty advisor, and I don't think you could find another faculty member anywhere at any law school who cares about the quality of the student experience and the quality of the product of students' work the way that Seth Lawn does. He's been an amazing mentor, an amazing friend of the board, and we're just so privileged to be able to learn from him. So thank you, Professor Lawn. And at this point, I'd like to turn it over to Molly Morgan, who will tell you a little bit about the facts of this case. Thanks.
Petitioner Melina Beckett, who challenges her removal from the United States, was born in Virginia. Beckett, a highly skilled computer programmer, immigrated to the U.S. in order to work for a large tech company in Santa Anita, the Silicon Valley of Arcadia. Several years after arriving in the U.S., her home country spiraled into civil unrest, and her co-religionists, the Baptists, were heavily persecuted. To help them, Beckett fabricated employment letters to facilitate their immigration, but she was caught and convicted under the state forgery statute. Years after her conviction, Beckett's employer was raided. During the raid, ICE turned off the lights and brought a canine unit with them. Beckett, during this raid, was detained for several hours, and during this interrogation, ICE discovered her prior conviction and initiated removal proceedings against her. The raid of her employer was conducted under the state's agreement with ICE. In fact, we have some footage of a press conference detailing this agreement.
Interrupt this program to bring to you an important message from the city of Santa Anita. The Arcadia State Police Department has joined forces with the Immigration and Customs Enforcement Agency to better protect the citizens of our great state. For more information on this initiative, here is a word from our sheriff.
Good afternoon, y'all. There has been a recent partnership with the Arcadia Police Department and the Federal Immigration and Customs Enforcement Agency, which I'll be referring to as ICE, to better protect those in the Arcadia community. This agreement with our police force and ICE allows our officers to enforce federal immigration initiatives. From this moment on, the Arcadia Jail will be notifying ICE when its detainees do not have lawful status to be in this beautiful country, the United States. Additionally, the jail has authority to hold a detainee up to 48 hours if it is suspected the individual is subject to deportation. Finally, be aware the Sheriff's Department will be executing immigration raids in the future. This is a response to the growing community concern.
I'm handling it, okay? Everything will be fine. I'll figure it out.
Excuse me, but Mayor, the editor of the Santa Anita News just sent these over. You might want to read them. People are not happy.
Ma'am, I just got back from the town hall meeting, and people are really uneasy with the number of foreign workers that's coming to light are working for Nebula.
Yes. Something must be done. Gary, get the sheriff on the phone.
After the horrible mistreatment of human beings and individuals through the human trafficking and drug ring that was recently uncovered here in our community, Arcadia is making it a mission to continue our work to ensure the safety and security of those within our city limits. At this time, I will take a couple questions.
Mr. Sheriff.
You in the green sweater.
Isn't it true that citizens in localities such as Santa Anita have expressed reluctance about the ICE-Arcadia partnership?
Yeah, well, that might be a little true. No law enforcement agency has formally refused to cooperate with the question. Let's go to the next question. Next question.
Sheriff, right here.
You in the front.
Isn't it true that agreements of this type were phased out during the Obama administration because of issues such as racial profiling?
There were a few things Obama phased out, not just when it came to these types of laws, other stuff too. But you know, we do believe in citizens' rights. We don't want to infringe upon them, but let's, you know what, let's just move. Next question. Next question.
Right here. Sure.
You way back, the guy that needs a haircut.
Mr. Sheriff, isn't it true that engineers from Virginia and other foreign countries are largely responsible for the booming success of the Santa Anita tech sector?
That might be the case. I mean, every group, there's good people, there's horrible people in each group. We like to weigh the pros and benefits and see which one is more important for the community. And in this case, we want to keep the community safe. Thank you for these questions. Very helpful, guys. Thank you.
And now Beck and I will introduce some of the issues you'll be hearing today. The first issue the competitors will argue concerns the scope of the exclusionary rule in civil removal proceedings. The exclusionary rule allows defendants to suppress evidence obtained in violation of the Fourth Amendment. In 1984, the Supreme Court, in a case titled Ynez v. Lopez Mendoza, held, in general, the exclusionary rule does not apply in civil deportation proceedings. However, at the end of the opinion, the court seemingly crafted two exceptions to that general holding, allowing the application of the exclusionary rule for widespread or egregious violations of the Fourth Amendment. Today, the competitors will argue the validity of both of these exceptions while also considering whether Lopez Mendoza itself should be overturned.
The second issue of the competition addresses when and how a state criminal conviction may implicate federal immigration consequences like deportation. Thus, immigrants who have committed state crimes rightfully may be concerned that they have risked their statuses in the United States, and that's at issue today. Melina Beckett was convicted of document fraud under the Arcadia State Criminal Code. If that state statute is described within the federal document statute and meets the required 12 months term of imprisonment, then Melina may have triggered deportation consequences under the federal immigration law. You will hear the competitors arguing today which tests apply to this analysis and accordingly whether the state criminal conviction is described in the federal document fraud state statute, such that Melina may have triggered deportation and may be required to leave the United States.
So at this point, we're going to go ahead and convene court. What that means is that we would like to have all cell phones off. Also, if you need to leave at any point, for any reason, we do ask that you not do so while the competitors are arguing during their 15 minutes of time. There will be like a couple seconds in between when the competitors switch who's arguing, if they come back up for rebuttal. In that case, if you do need to leave for any reason, you may do so quietly at that point. Thanks so much, and we'll get started.
All rise. Oyez, oyez, oyez. The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. Good afternoon, everyone. The case for argument this afternoon is Beckett versus United States. We'll first hear from Petitioner Beckett. Ms. Murphy.
Good evening, Mr. Chief Justice, and may it please the court. My name is Kira Murphy, and I am here on behalf of the petitioner in this action, Miss Melina Beckett. 33 years ago, before Ms. Beckett was born, the Lopez-Mendoza Court declined to extend the protections of the Fourth Amendment exclusionary rule to what were then referred to as civil deportation proceedings. This decision was based upon a determination that the social cost of implementing the rule would outweigh the social benefits. While this may well have been true at the time, the assumptions that this determination was based on have since been tested in real-world state and federal law enforcement and are no longer, then have not withstood the test of that time. We ask this court to respectfully reconsider the decision in Lopez-Mendoza, or in the alternative, broadly interpret the egregious and widespread exceptions to the ban on the exclusionary rule in order to better deter law enforcement misconduct and affirm the guarantees of the Fourth Amendment.
Standard of review that we're going to apply.
This is a de novo review because this is a question of constitutional interpretation.
So what would be the reason for us to reconsider a precedent? Obviously, we can, but what would be the reason we would do that? What's the overriding reason for us to overturn it and establish a new rule?
Yes, Your Honor. So, as I said, in Lopez-Mendoza, the court looked at a balancing test weighing the deterrent value of the Fourth Amendment rule on deterring law enforcement misconduct and the social cost of implementing the rule as far as the loss of probative evidence. The court determined that there was a low deterrent value based on 4 factors, and it is our opinion that those factors no longer point to banning the exclusionary rule in this context. For example, the court said that part of the low deterrent value was based on the fact that ICE had in place internal systems for regulating officer misconduct.
Here we're talking about just a date, right? The visa expired on a specific date.
Yes, Your Honor.
Let's assume you're correct and we apply the exclusionary rule. Couldn't another doctrine, such as the inevitability doctrine, discovery doctrine, apply in this case? Wouldn't they have eventually just discovered the date and we'd be in the same position, deportation?
Well, Your Honor, the government has conceded that they have no other evidence in this case other than the evidence seized in the I-213 form to prove Ms. Beckett's alienage. Therefore, it is not likely that she would be deported in any other realm because of the fact that the evidence in the I-213 form should be suppressed.
Counsel, your argument presupposes that the Fourth Amendment applies to your client. Is there any authority from our court that supports the idea that a non-citizen is entitled to protection under the Fourth Amendment under these circumstances?
Yes, Your Honor. The dicta in Lopez-Mendoza seems to presuppose that non-citizens are entitled to Fourth Amendment protections in the criminal context. And we would argue that the deportations proceeding have become very criminal in nature, and that's why.
If it were criminal, then there'd be then the exclusionary rule would clearly apply. And that's really what we're arguing about. So
correct.
Is it the case that whether the exclusionary rule applies and whether the Fourth Amendment itself applies necessarily coincide?
Yes, Your Honor. So as I said, in dicta, it seemed this court seemed to imply that it would extend that non-citizens would be protected by the exclusionary rule in criminal proceedings. And
so you're acknowledging that Justice O'Connor's comments were dicta?
Justice O'Connor's comments were dicta that were joined by 8 justices, but the comments I'm referring to are the fact that they specifically cited that Ynez in that argument was not arguing that if this were a criminal case, the Fourth Amendment would not apply. So, and I think that's earlier than the opinion than Justice O'Connor's.
But of course, they're called civil deportation hearings, aren't they? Back at the time of this the Lopez decision, it was called a civil deportation hearing. So why, given the context there, that this is in fact a civil proceeding, would a purely criminal context constitutional right apply?
We would argue that this court has indicated in Padilla v. Kentucky, for example, in 2010, that deportation has become very entwined with the criminal process. This is a harsh penalty to impose on somebody that the court in Padilla v. Kennedy said is akin to banishment or exile. Furthermore, one of the reasons that the justices said the deterrent value was low was because most people at the time of Lopez-Mendoza chose voluntary removal as opposed to the formal deportation process. The statistics were something like over 97% of detainees chose to be voluntarily returned to their home country. This is no longer the case. From 2015, less than 30% of detainees are voluntarily returned to their home country, and this is on account of policy decisions made by the executive and the legislature to encourage people to go through the formal removal process in order to gain the criminal enhancement that comes with re-entering the country illegally once you have been formally removed, as opposed to the less harsh standard that comes from being voluntarily returned.
It sounds, counsel, like those policy changes and the behavioral responses to them change the Constitution.
I don't necessarily think that they change the Constitution. I would say that I don't necessarily agree with the decision in Lopez Mendoza, in that I think the Fourth Amendment protects all people and that people should not be used as a limiting word to citizens.
This doesn't have anything to do with your opinions. It has to do with the law. What is the legal basis for that position?
That the Fourth Amendment should extend to all people, in that the value of the Fourth Amendment exclusionary rule is to deter government misconduct, and if you exclude one group of people who are in the country, you are basically making vulnerable every group of people. I mean, in this raid that was conducted on Nebulae, it was not just Miss Beckett that was subject to the harsh treatment of the government and the government's excessive actions. It was everybody in the building. And if ICE agents are allowed to do these kinds of things, conduct these sorts of raids unfettered, it not only harms Miss Beckett, but it harms the entire citizenry and non-citizenry of the United States.
You started the argument with an alternative, and that is Fourth Amendment applies, but if not, perhaps there's a middle ground. It comes out of Justice O'Connor's opinion. And I'm interested to see what your argument is in regard to egregiousness or widespread problems which would create an exclusionary rule.
Correct. So I believe that Justice O'Connor did create an egregious exception in Ynez v. Lopez Mendoza. She said specifically that case did not apply to egregious violations. And we believe that this is because if you look at an egregious violation, it becomes very clear that the social cost no longer outweighs the social benefit of not applying the exclusionary rule.
It sounds, counsel, as though you think the exclusionary rule is the only deterrent that's in play here. But that's not correct, right? We also have civil damages, for example, that should be available in a case like this, particularly to folks who are either U.S. citizens or here legally, who are caught up in these kinds of Fourth Amendment violations. Why is that not enough?
Correct, Your Honor. Civil remedies are available to certain people in that context. I have sort of two answers to that question. One, that is not a remedy that would be available to Ms. Beckett. It is not realistic that she would have access to the federal court system after being removed. Furthermore,
well, of course not, but it's not. I thought you were arguing that the principal reason we want to worry about this is that, an important reason is that if immigration agents have the kinds of powers to conduct raids like this, they're going to sweep up a lot of other people and harm their Fourth Amendment rights. And they've all got civil remedies available, right?
That is correct.
So
However,
why not? Why is that not good enough?
So, as Justice O'Connor points out in her opinion, she says one of the reasons the deterrence is low is because ICE operations are often very confusing and chaotic, and it's not realistic. She says it is not realistic for ICE officers to understand whether or not they're violating the Fourth Amendment rights of each individual person caught up in a mass arrest. This might be true, but it also means that it would be very hard for an individual person to bring a suit against the government if ICE has provided no evidence of what happened during that raid because it was so, quote, confusing and chaotic. They would have very little evidence because no one is looking out for which individual's Fourth Amendment rights are violated in a context like that.
Or which individual officer is violating them.
Correct.
Can I ask you about egregiousness, because that's the heart of you. You left out the other aspect, and I appreciate that. The egregiousness, what she read or what she wrote. We do not deal here with egregious violations of Fourth Amendment or other liberties that might transgress notions of fundamental fairness.
Correct.
Right? That's the concept. The concept of fundamental fairness is, in fact, not a Fourth Amendment concept. It's of due process. And it really is related to Rochin versus California. She's talking about in a case in which there is a violation of fundamental fairness, there may very well be a due process argument. That's not exclusionary rule. That's not Fourth Amendment, is it?
I think that I would agree that it probably extends to a due process claim as well, but I think it can be found in the Fourth Amendment in that, for example.
Where is it then in her comment here which indicates that she's thinking about the Fourth Amendment as opposed to fundamental fairness and due process?
I think it's in the context of she says that we don't deal here with egregious violations of the Fourth Amendment or other liberties which transgress fundamental notions of fairness.
Well, she didn't say anything about the Fourth Amendment.
My-
Oh, I'm sorry. No, you're right. No, earlier on, she does. No, you're right. We do not hear with egregious violations of the Fourth Amendment or other liberties that may transgress notions of fundamental fairness. You think that links it to a Fourth Amendment argument as opposed to due process?
I think it could be interpreted as both. I think other liberties could refer to due process, and the Fourth Amendment, egregious Fourth Amendment violations would refer to the Fourth Amendment. For example, Ms. Beckett here, it appears, was singled out based on her race, which we would say, especially under the Ninth Circuit's bad faith standard, constitutes an egregious violation of the Fourth Amendment.
I'm curious about that argument. Obviously, we're very troubled by racial profiling in a lot of different contexts, but with immigration, national origin is what it's all about.
Correct, but this is different. Race is different than national origin. It is, what does a Verdinian citizen look like? Just like what does an American citizen look like? It's impossible to tell. In United States v. Bergoni-Ponce, it says that you are allowed to use objective characteristics of national origin in order to determine whether or not somebody might be in the country illegally. That's as just one of the factors. Objective includes things like mode of dress or accent, but not visually what somebody looks like. We just ask that this court, like I said, overturn Lopez-Mendoza or reconsider the egregious and widespread exception. Thank you.
Okay, you're reserving 3 minutes for rebuttal. All right, thank you. We'll next hear from the United States. Mr. Van Dyke.
Mr. Chief Justice, and may it please the court, my name is Alex Van Dyke, and I represent the United States. This court has repeatedly emphasized that the exclusionary rule hinders both truth-seeking and effective law enforcement, and for that reason, Your Honors, it has always been a last resort. Ms. Beckett is an undocumented immigrant subject to removal from the United States, and because the Arcadia State Police did not egregiously violate her rights, the exclusionary rule should not apply to her case. So first, Your Honors, this court's decision in Lopez-Mendoza should not be overturned. Stare decisis ensures principled and reliable laws, and here there's not a compelling reason to change course.
Counsel, on that theory, though, we've changed a lot of our precedents involving the exclusionary rule, cutting it back time and again, in essence treating it, the remedy, as an experiment. So why isn't empirical experience a sufficient basis for reconsidering such a rule?
Your Honors, I'm not arguing that you could never reconsider such a rule. I'm arguing that in this case we shouldn't, because the truth of the balancing test is still there. Still to this day, the cost of applying the exclusionary rule in the immigration context greatly outweighs the deterrent value that it can add. And that's that balancing test is the rule that this court consistently applies for whether or not to apply the exclusionary rule to a particular case. So first, there's the fact that the cost is very high. As with any time the exclusionary rule is applied, there's always the grave cost that probative evidence will be excluded and dangerous criminals will be released.
Well, that's the deterrent effect, isn't it?
I'm sorry, Your Honor?
That's the deterrent effect.
Yes, Your Honors, but I'm talking here about whether the social cost of excluding that evidence is going to outweigh that deterrent effect.
I just want to make sure I understand your argument. Are you saying that we should never apply the exclusionary rule, or that under these particular facts on this record, there's not sufficient evidence of egregiousness that would allow the application here?
Your Honor, I'm arguing for upholding Lopez-Mendoza, which means typically not applying it. We do agree that there should be an egregious exception, but that it wouldn't apply in this case. So right in line with Lopez-Mendoza.
Is that consistent with stare decisis, or are you asking us to depart from stare decisis?
No, Your Honor, I think I'm asking you exactly to apply Lopez-Mendoza on its face.
Your colleague makes the argument that deportation immigration proceedings are akin to criminal proceedings and that we should. Given what we know and what we've seen lately of the types of proceedings and the arrest procedures of ICE agents, do your colleagues have a point the way people are arrested, the way that immigration agents go in, the way people are detained for lengthy periods of time. Do your colleagues have a point about that?
Your Honor, I would agree that there are some similarities in the way that raids are carried out with the way that other police work can be carried out, but nevertheless, deportation is still, and this court has consistently said this, different from a criminal proceeding. My opposing counsel pointed out the case of Padilla v. Kentucky, which did talk about these becoming meshed, but in the immediately preceding sentence, it said, nevertheless, removal proceedings are civil and it is not a criminal sanction. This court reiterated that in Arizona v. U.S. 2 years later.
We're talking about costs, though, of the exclusionary rule. It sounds like the costs here would be that a talented software engineer with a history of humanitarian compassion for fellow religionists would be returned to an extraordinarily unstable and violent country. It sounds like a cost to me if we apply the exclusionary rule.
Your Honor, we're not arguing that Ms. Beckett would necessarily fall into this category of dangerous criminals, but that would be the implication of applying the exclusionary rule to every single removal proceeding. And that cost has been laid out by Justice Scalia and Hudson. It's simply going to happen that when probative evidence is excluded, it is possible that dangerous criminals will be released into society. And that's every time the exclusionary rule is followed.
So when you are applying egregiousness, you're applying a totality of circumstances test. Is that correct?
Yes, Your Honor.
So I'm really curious to hear what your argument is in response to the assertion that was made in the briefs that the agents walked in, they shut off the lights, they had dogs barking, they isolated Ms. Beckett because of her race, theoretically, or her appearance. They kept her essentially isolated, although viewed by others in an embarrassing situation. They prevented her from food, from using bathrooms, all over an extended period of time. I'm curious to hear why you think that isn't egregious conduct.
Absolutely, Your Honor. I'll start with the question of whether or not Ms. Beckett was selected based on her race. There's nothing in the record to clearly indicate that she was. The only evidence of racial profiling is one sentence from the immigration judge saying that ICE officers or the Arcadia State Police selected people apparently based on the appearance of being Verdenian.
What extent are we bound by that? I mean, you've got the judge essentially saying that race was a factor in the selection of Ms. Beckett. And that person was right on scene during the course of the hearing. Why can't we accept that?
Well, Your Honor, because the immigration judge then went on to explain that she legally understood racial profiling should be a means for finding an egregious violation, but then didn't find one. So clearly, although she included it in her statement of facts, she didn't actually think that there was the kind of illicit racial profiling, meaning race acting as the sole grounds for detaining someone, which is what the circuit courts have looked for. She clearly didn't find that, otherwise she would have found an egregious violation. And there's no other evidence in the testimony to indicate that race was actually a factor. But next, Your Honors, I would also like to move on to some of the severity of the conduct that you were talking about with the length of the stop. So I'd like particularly to point this court to the case of Ynez Marquez v. Lynch on the Fourth Circuit. Now, in that case, ICE officers had a warrant to enter a home, and similar to the warrant in this case, it didn't particularly list the defendant. But then once inside, ICE officers broke down bedroom doors and then pinned the defendant to a ground with a gun to her head and detained her for 4 hours without letting her use the restroom. Obviously very similar facts. There, the Fourth Circuit held, while no doubt this action was frightening to the defendant, it still was not an egregious violation because it ensured officer safety in a dangerous situation. And this court has encouraged exactly such command. In Michigan v. Summers, this court said...
What's the name of the corporation?
I apologize,
What's
Your
the name of the corporation in this case?
Nebulae.
A high-tech company producing software that's akin to someone's home? Do you see there's a distinction between the two? ICE was going to a corporation, a software company, brought dogs. I mean, we can kind of see that going to someone's home where you don't know where they have weapons. You think ICE thought these workers had weapons under the seats or under their computer somewhere?
I think that's going to cut both ways, Your Honor. On the one hand, yes, it's possible that there's slightly less chance that there would be weapons, but there's also a much lower expectation of privacy in the workplace. So To that extent, I think it should still be easily analogized to Ynez.
Right, but you
Marquez.
were premising it on officer safety in a dangerous situation and explaining why the totality of the circumstances made it egregious. If you're not going to look at the circumstances of the target, the potential person up for deportation, then you have to look at the totality of the circumstances, assuming that you don't want these officers willy-nilly violating the Fourth Amendment, right? So.
Yes, Your Honor, and this was still, anytime an immigration raid is carried out, it is still a dangerous situation, and especially in light of the fact that the officers received resistance from the very first employee that they met. And I'd like to again, yes, Your Honor.
So you call resistance suggesting to officers that they may not have legal authority to enter the premises?
Your Honor, I think the record actually makes a distinction there. So it says first that she requested that they stick to the 3 people listed, which is not, the officers were not legally bound to only detain those 3 people based on international molders in the Ninth Circuit. And then in another sentence, it says she offered some resistance. So I think there is a distinction between her asking to keep to those 3 people and then later offering some resistance, and based on the record, we don't know what it was.
But you do have precedent here. You have Supreme Court in Ynez versus Delgado, which deals with the same essential issue. But the facts are so dramatically different. In Delgado, the agents went in, they kept the business going, they didn't harass in any particular way. In this particular case, everybody's head had to be, essentially off work. They had to be, their hands were on the desk. They couldn't be doing anything in regard to their operation in general. But then also, of course, she is restrained in this particular kind of way. Isn't that a dramatically different kind of fact scenario than what the Supreme Court had resolved in Delgado?
It is dramatically different, Your Honor. And in Delgado, the Supreme Court said that the brief questionings there didn't even implicate the Fourth Amendment. We fully realize that this stop here did implicate the Fourth Amendment, but the police officers were acting pursuant to a valid warrant that gave them the suspicion necessary to detain Ms. Beckett. And I'd again like to point for the necessity of putting the hands on the desk and taking such command of the situation. I'd like to point this court to Michigan v. Summers, in which this court said it's best for everyone, both officers and the people to be searched and seized, that officers have unquestioned command over the situation and ensures everyone's safety. So again, Your Honors, I don't think we're dealing here with the type of severity of conduct that this court or any of the circuit courts has been worried about, given the authority that the officers had to be at Nebulae conducting this raid. If I could, I'd also like to move on to my opposing counsel mentioned the notion of bad faith. Now, limiting egregious conduct to bad faith would be both wildly over-inclusive and under-inclusive in a couple of ways. And for that reason, we do argue that the totality of the circumstances should apply, but bad faith should be one of those circumstances to be considered. That would be the Fourth Circuit's test that they use. And the reason bad faith would be too broad is because in theory, it could sweep in any very small violation that would in no way be akin to, say, the case of Roshan, which is the case that Justice O'Connor thought best exemplified egregious conduct. It would sweep in very small violations so long as an officer should have known better. It could also potentially be under-inclusive, and as long as an officer had some reasonable justification for what he did, no matter how bad the conduct was, it wouldn't trigger this egregiousness exception. So hanging everything on bad faith should not be the test that the court follows.
Sorry, are you suggesting it's objective or includes a subjective analysis in that test?
Your Honor, there's definitely a subjective part of this test, but it doesn't have to come with no objective lines. A couple that could be drawn for...
We have steadfastly tried to keep subjectivity out of our Fourth Amendment jurisprudence. You want us to introduce it here in terms of evaluating egregiousness?
Yes, Your Honor. I think given how fact-specific of an inquiry this is, there's not a way around it. And there's still other instances in which the totality of the circumstances has to be taken into effect, and there's some subjectivity. Whenever reasonableness is in play, you have to look at all of the facts of the officers to determine, for example, if they have reasonable suspicion to stop somebody.
But again, is that an objective test or a subjective one?
It's going to have certain objective lines, but there's still subjectivity and considering all of the circumstances.
So then you're telling trial courts to begin to assess what a police officer is thinking. What's the subjective approach to the fact scenario?
Not just what he knows.
That becomes more and more important under your particular theory, and is that exactly where you want to go?
I don't think so, Your Honor. I think I'm arguing just to look at the facts and look at the conduct and see if what the officers did violated the defendant's fundamental fairness.
I thought you were talking about subjective intent.
I didn't mean subjective intent, Your Honor. I mean that there is just a part of this that's going to have to be up to the judge to subjectively determine exactly what violates fundamental fairness. But, thank you, Your Honor. If I could, I'd also like to move back to why Lopez-Mendoza should continue to be upheld. So based on this egregiousness exception, which provides a good compromise between what my opposing counsel and I are arguing for, it offers an effective immigration system, but protects people from the absolute worst kind of Fourth Amendment violations, Lopez-Mendoza is a good decision. As I already mentioned, there's the cost of excluding probative evidence. There's also the fact that our immigration courts are not equipped to handle the tidal wave of suppression filings that would come from applying the exclusionary rule to every single immigration proceeding. And then on top of that, in light of those high costs, there's the low deterrent value. As Justice Hamilton mentioned in my opposing counsel's argument, there are already alternative remedies like 1983 actions. Although this court has questioned the force and availability of those actions, in Hudson v. Michigan, Justice Scalia said that they continue to grow in their availability. There's now an explosion of public interest law firms. And
when is the last time this court, let's get away from Section 1983, we're focusing here on federal agents. When is the last time we expanded Bivens liability?
I apologize, Your Honor, I'm not aware.
We've been cutting it back for 40 years. So it's hard to see that as much of an additional deterrent.
It is still an additional deterrent. Bivens actions do actually now exist, which they didn't exist when this court was most skeptical of 1983 actions back, especially in Mapp v. Ohio. And that's Justice Scalia's point in Hudson, is that still, nevertheless, 1983 actions do continue to grow in their force and availability. And on top of that, as Justice O'Connor mentioned, in a collateral criminal proceeding that would come alongside a removal proceeding, immigrants would receive exactly the same, and they do receive the same Fourth Amendment protections. In that case, the exclusionary rule would apply. Thank you, Your Honors.
All right, thank you, Mr. Van Dyke. Rebuttal, Ms. Murphy.
Your Honors, my opposing counsel has conceded that raids carried out by immigration officials are very similar to raids carried out by police in other law enforcement proceedings. As pointed out by Justice White in his dissent in Ynez v. Lopez-Mendoza, the primary objective of ICE agents is to obtain evidence for civil deportation hearings, the same way that police are. Their primary objective is to obtain evidence for criminal proceedings. This puts it in exactly the same place as other Fourth Amendment exclusion, in other proceedings where the Fourth Amendment applies. And to argue that ICE agents would be less effective if the Fourth Amendment exclusionary rule were to be applied is to say that in all proceedings where the Fourth Amendment is applied, law enforcement is less effective, which is true, but that is the cost we pay for the rights that are affirmed to us by the Fourth Amendment. And to argue that administrative efficiency should make rights subservient to that, in that the courts are somehow not capable of handling these motions to suppress, is to say that these rights are less valuable than the Fourth Amendment rights extended to all citizens and non-citizens. And therefore, means that the judiciary is working hand in hand with law enforcement to basically take away these rights from people, and that is not the goal.
Not a good thing.
Not a good thing. Additionally, if we look at my opponent has brought up the difference between the totality and the totality of the circumstances test and the bad faith test. As you have all pointed out, the totality of the circumstances test involves a lot of subjective and non-objective lines to be drawn, and that is very difficult to do. The bad faith standard, which is whether or not a reasonable officer should have known that they were violating the Fourth Amendment, creates a bright line rule for officers to conform their conduct to. It allows officers to have leeway when they believe that they are acting in good faith, which is the same exception that was applied in U.S. v. Leon.
But you're not suggesting this is a subjective test of officer good faith, even though you're calling it a good faith test.
I would call it a bad faith test in that, but I would say it is an objective test in that a reasonable officer should have known that they were violating the
Depend
Fourth
upon a
Amendment.
reasonable officer, not necessarily what that officer was thinking at that point.
Right.
And to that extent, you differ from the government.
Exactly. And that is the test that was laid out by the Ninth Circuit in Guerra v. Gonzalez, that they said a reasonable officer. Therefore, I think that allows this court to maintain the objectivity in Fourth Amendment law that it has been trying to obtain through
And
precedent.
even if you use totality of circumstances as a test, take the Second Circuit test, that still, when you're talking about bad faith, is just an element, but bad faith is based upon the objective analysis, not a subjective thought about what a police officer is thinking at that particular point.
Correct, Your Honor. That's what I would agree. Thank you very much.
Okay, thank you, counsel. And for the audience's benefit, we will now shift from the Fourth Amendment to the intricacies of recidivist statutes. Some of you, I gather, are familiar with that topic. Okay. We'll hear from Petitioner Beckett, Ms. Haney.
Good evening, Mr. Chief Justice, and may it please the court. My name is Carolyn Haney, and I represent the petitioner, Melina Beckett. This case is about whether or not Ms. Beckett will be per se deportable based on a conviction that resulted in a sentence of 1 day time served, community service, and probation. We urge this court to find that the sentence is insufficient to be considered an aggravated felony under the INA. However, if this court does find that the sentence is sufficient, we urge the court to overturn Ms. Beckett's order for removal, as the statutes in this case are not a match. First, we see that the court should find this conviction insufficient under the INA to be considered an aggravated felony. The INA requires that there must be a term of imprisonment of at least 12 months for a conviction to be considered an aggravated felony. Here, Ms. Beckett received a mere 1 day sentence of time served.
Doesn't that mean there must be the possibility she could serve a year?
No, Your Honor.
You think it's the actual sentence?
No, Your Honor. We can see in U.S. v. Graham that we're looking at the sentence that was actually imposed. And we can see that there's good reason for this. Rather than looking at the minimum or the maximum, we look at what a judge decided was appropriate in that specific case. In this case, we see that the judge felt it only appropriate to sentence her to that 1 day of time served, no additional time was given, as well as community service and probation. As we can see, probation...
Counsel, maybe I'm misremembering, but I thought we were worrying about a suspended sentence in this case.
No, we are not worried about a suspended sentence. In this case, she was given probation.
Why should there be a difference? Why should there be a difference between 0 to 1 year suspended in probation as opposed to 1 year probation?
Well, as you can see, if you're given a suspended sentence, you are actually given that sentence. When you're given probation, you are given a certain set of guidelines that you must check in with an individual, and then if you were to violate, at that point, a judge may find it sufficient to present you with a sentence of a year at that time. So therefore, there's a difference between having a sentence and having it suspended, or having a probation and then the possibility of perhaps a sentence in the future. And we see in this case especially, Ms. Beckett successfully completed her probation, so a sentence was never actually given to her. If this court were to find that that sentence was sufficient, the court should still overturn Ms. Beckett's order for removal, as the statutes in this case are not a match. First, we determine whether the statutes are a categorical match. To do this, you look at the language and see if they nearly mirror one another. That is not the case. We see that there are verbs that are different, as well as the documents listed are different in each. Next, you determine whether the statute is divisible or indivisible. To be
Can I just ask you, what's the difference in the verbs?
In the
talking about
verbs-
alters?
We see adjust is listed in the state statute that is not in the federal statute. Once we determine whether or not...
What about alters? Does not alters mean adjust if one looks to a dictionary? And in which case, if that's true, then aren't they virtually identical?
No, alters does not mean adjust. While they may have a similar meaning, you may be able to adjust something in a way that you wouldn't permanently alter it. Additionally, we see that the legislature put both of these
Explain
verbs...
that to me.
Yeah, that's right. Oh,
let's say to adjust, let's say we're talking about a passport. If we adjust it, let's say the cover, we may bend the cover in a certain way, but if we alter it, then we would have to change
No one
something
ever talks
on it.
about passports as being adjusted. They are altered, right?
Your Honor, they may be fairly similar, but we see that the legislator included them for a reason. And so therefore, they are still different and they are not a
Are you
match.
saying that for a categorical match, you need the exact same words as opposed to synonyms?
They need to nearly mirror one another. And that is not what we have in this case.
So, in other words, there's some conduct which would be culpable in a state statute which is not culpable in the federal, or vice versa, just because of the differences in the words between alters and whatever.
Yes, and it can seem like it's a bit of a slight difference. However, we see in these cases that it's extremely important to be precise with the language that we use because the consequences are so broad. When we're considering someone to have committed an aggravated felony based on a state conviction, we need to be certain that they actually would have committed that crime under the federal statute because they'd be subject to deportation. And deportation, we can see, especially in this case, is an extremely severe penalty. We see that Ms. Beckett would be sent back to Virginia, where she may face religious persecution.
Counsel, is this ultimately a state or a federal law question?
This is a federal law question.
But informed by what the state law means, is
Yes.
that right? Now,
Yes.
is there any authority for the idea that we would certify to a state Supreme Court what this state law question is, so we can learn authoritatively from the relevant state what we're talking about here, whether adjust means alters or something else altogether?
No, Your Honor. We see in the case law that you are just to look at the language of the statute, and then you are also allowed to look if the statute is divisible and you can apply the modified categorical approach, you can look to the plea agreement to then see whether or not what they were actually convicted under the state statute does apply under the federal statute.
So if she's found to have been convicted of an aggravated felony,
Yes.
how does that impact her ability to request asylum protection or cat protection?
She would not be able to do so. She would not be given any deferential.
What year
relief.
was this conviction?
This year, the conviction was in 2014.
And the raid is in 2017?
Yes.
Should we read anything into the 3-year delay?
Yes, we should, Your Honor. We can see that she successfully completed her probation and has since not been in any trouble with the law. Therefore, we can see that the main purpose for having an aggravated felony, where we could exclude an individual from the country, making them per se deportable, that is not as pressing in this case. Another reason we want to be so careful to make
Is that
sure...
a policy reason, or is that listed anywhere in our precedent?
That would be a policy reason, Your Honor. Even if this court were to find that the statute is divisible, we would look to the language that is used in the plea agreement to see if it is a match with the language in the federal statute. We see that Ms. Beckett pled guilty to having helped create unauthentic employment letters and other evidence of career-related achievements for use by Verdanian citizens. Create is not one of the verbs listed in either statute, so even if the words are read to be elements, we cannot tell which one Ms. Beckett was actually pled guilty to. Additionally, we can see that employment letters are not listed anywhere in the statute. Therefore, we would have to read in that that would qualify as one of the other documents under the federal statute.
Is there any doubt that she was forging employment letters that were being used to obtain immigration benefits?
Your Honor, all that we can see in the plea agreement is that she helped create employment letters and other forms of career-related achievements that were then subsequently used as a part of a petition for an employment visa. So we cannot tell whether or not helped create isn't necessarily synonymous with forging. Additionally, This
sounds like we're splitting hairs at a very fine metaphysical level, and I wonder whether we might not want to reconsider the entire categorical approach to this problem, and instead ask if there is reliable evidence of what the petitioner actually did that led to her conviction. We ought to focus on that reality rather than these hair-splitting tricks.
Your Honor, I agree that sometimes it seems counterintuitive to look at something that you could reasonably infer would have fit under the federal statute. However, I believe there is strong reason to affirm U.S. v. Shepard and look only to the actual language used in the plea agreement because the consequences are so severe. We want to have that level of certainty without having to go back and weigh the facts and see whether or not an individual actually may have committed the crime under the federal statute.
I'm for certainty. I'm not sure I find it if we're trying to figure out the difference between divisible and indivisible statutes here.
Your Honor, divisible and indivisible is based on whether or not the verbs listed are elements or means. So when we're determining that, we don't necessarily need to look only to the language. You can look.
What is your argument? Is it divisible or is it not?
We assert that this is indivisible because they list means as opposed to elements. We can see that forging, altering, and adjusting all would lead to the same end result. You would have a document that wasn't completely authentic.
Okay, assuming it's indivisible, what's the next test?
If it's indivisible, then you would go back to that categorical test, and because on their face they are not nearly mirroring one another, then it would not be able to be an aggravated felony.
And let's say the court feels it's divisible.
Yes.
And you use a modified categorical approach.
Yes.
Then how would your argument adjust to reflect that different approach?
Your Honor, if you found this to be applicable under the modified categorical approach, you would then look to the language in the plea agreement and see if that language matches the federal statute. In this case, as I've illustrated, there are a few different areas where that language is not the same. And it may seem like we're splitting hairs in some ways to say we can look at the factual record and see maybe you feel in all likelihood this might have been what she did, but there's good reason to require that there be that certainty so that not only we don't risk grouping people in over broadly, people who may not deserve to be convicted under the statute, and then making them per se deportable, but you also ensure that individuals are certain of what they're pleading to when they are pleading to that state conviction. We see in this case that Ms. Beckett looked at length with her attorney over the state statute, and they said they would not have pled guilty if she had thought in any way that it could have been a categorical match or a modified categorical match with an aggravated felony under the federal statute. We see that it's not fair to allow an individual to...
You're not suggesting you're throwing that argument in at this point, that she never would have pled guilty if she had known that this was going to have an impact upon her being able to request asylum, are you?
We actually see in the record that her counsel has asserted that they would not have pled guilty if she had thought it would be an aggravated felony. We see that on page 36 of the record in footnote 19.
So is there some place where she petitioned the court to withdraw her guilty plea?
No, she did not, because as we can see, she successfully completed all of her punishments related to that conviction. So at this point, this is 3 years later, it would have really not been practical for her to have petitioned the court to withdraw her guilty plea at this point. If there are no further questions, I will conclude until rebuttal.
All right, thank you, counsel. We will hear next from Ms. Stemnock for the United States.
Good evening, Mr. Chief Justice, and may it please the court. My name is Mary Pat Stemnock, and I represent the respondent. Since the advent of the American criminal justice system, certain crimes have been considered more serious than others.
All right, this is where I need you to convince me about how serious this is. There's a 3-year delay between the government filing this action. When it found out that the conviction happened in 2014, and we're now in 2017. We all know the prosecutors love to pile on charges. Isn't this an example of that? If this was really an aggravated felony, would the government really have waited until 2017 to try to remove the petitioner in this case?
Your Honor, I think the facts here show, or the relevant facts here are not whether the severity of the crime or what she did. The fact here is that if an individual commits an aggravated felony, then they can be per se removable.
That's what I mean.
Right.
If it was per se, if this happened in 2014 and it was per se, wouldn't the government have acted immediately rather than wait 3 years?
Your Honor, the reason why the government acted now is because with the evidence in the I-213 form saying that Ms. Beckett was here illegally, she can now be found guilty of an aggravated felony. And the facts show that the aggravated felony did occur. Whether it may not have been as serious of a crime as others, they had to abide by the statute, which said that if an individual completes an act of fraud, it is an aggravated felony, and that's what the government did, is abide by the statutory guidelines.
Could you address the seriousness of the sentence issue?
Sure. So Beckett's offense is an aggravated felony, Your Honor, because the state crime did provide a term of imprisonment of at least 12 months.
The state statute allowed it, or the court's judgment?
The state statute allowed a term of imprisonment of at least 12 months. In the INA, the definition of term of imprisonment is a period of incarceration or confinement ordered by a court of law regardless of any suspension or imposition of that sentence.
Ordered, not authorized by the statute, right? Ordered by the court.
Oh, I apologize.
If the sentence here is just a day, those of us on the bench who have imposed sentences before know that a sentence of a day is in a case that you don't take very seriously and is a harm.
Your Honor, however, here the INA says that this term of imprisonment is regardless of any suspension. What happened in this case was that Beckett accepted a plea deal where the government realized that because of her humanitarian motives, she did not deserve as harsh of a punishment. So what the government did was give her a term of probation and a term of community service instead. So this was an example of a suspended sentence.
But don't you think that they also may have structured it the way they did because they didn't want it to qualify as something, an aggravated felony? I mean, that it wasn't in light of her humanitarian acts, it was in light of the relative lightness of the crime itself. And that they didn't want to trigger the immigration repercussions for her.
Your Honor, that could be the case. We don't have any facts in the record that indicate that that was their intention. So because the crime does meet that term of imprisonment, it is considered an aggravated felony.
But a suspended sentence is a sentence that a court imposes which follows this framework. That is, X number of months suspended and then probation. That's not what happened here. This was just a straight probationary sentence. There was no suspended sentence, was there?
Your Honor, this was not an example of a straight probationary sentence because she was given jail time. And
One day.
That is correct. However, that was jail time, which indicates that this is not a case of straight probation.
No, I appreciate that, but is there a suspended term? So, in the example that I just gave you, 1 year suspended probation, it's a 1 year suspended term. Is there a suspended term here, or is there not?
Your Honor, the record only indicates that Beckett accepted a plea deal with a sentence that was suspended based on the humanitarian motive.
Could you quote it, please?
Yes, it says...
And are we talking about, and please quote the court judgment.
Your Honor, I do not have the text of the court judgment in front of me.
Okay.
I simply have
What
that...
do you want to quote?
I'm sorry, I can't.
No, what do you want to quote?
I could quote the language that I have in front of me, but it is not from the court.
Which document?
It would be a summary of what the court said.
Okay, go ahead.
However, as I said, this is a term of imprisonment because regardless of any suspension, that term of imprisonment is the time imposed. So therefore, the relevant consideration is not how many days she spent in jail. And several circuit courts have confirmed this. The Third Circuit, Second Circuit, Eighth Circuit say that the consideration is the term imposed and therefore not how many days were spent in jail. And Ms. Beckett's sentence was a term that was at least a year.
Is there anything in the record about terms and conditions of probation that were a part of her sentence?
Your Honor, we simply have evidence that she was placed on probation and that if she violated the probation, she could be potentially reincarcerated.
Counsel, you noted earlier just the humanitarian motives behind Ms. Beckett's crime and the agreement to have her spend just 1 day in jail, which she had already spent at the time she pled guilty. And yet now we're being told this is so serious that she should be returned to this violent, dangerous land where she'll be in great danger.
Your Honor.
It's a little hard to see the government's point of view here.
Your Honor, while the government understands that Ms. Beckett has been a productive citizen, she has...
Not a citizen.
Or productive non-citizen.
Unless you're conceding that point.
No, sorry. Productive non-citizen. She has been a productive citizen. She has had humanitarian motivations. But the law does not consider motive. The law does not consider intent. The law considers whether she committed an aggravated felony. And the facts here indicate that she did commit an aggravated felony. APC 113 is a divisible statute, not an indivisible statute, as the petitioner argues. And therefore, we can look at the plea agreement under the modified categorical approach to determine that her conduct under the state statute is also contemplated under the federal statute, and therefore she committed an aggravated felony. So the first question would be whether the statute lists elements or means. This statute lists elements. In Mathis, this court defined means as circumstances or events having no legal effect or consequence. Those are not the words that we have here. The words that we have here, forge, alter, adjust, and use, are not means of committing the same act. They are individual elements. This is especially true in looking at the word use. Forge, alter, adjust, and use are not synonyms. Therefore, how can they be means of committing the same act? This court further explained...
Should we divide it with uses as separate and treat forges, alters, and adjusts together?
Your Honor, we believe that the fact that use was included was the legislature's way of indicating this was not meant to be an indivisible statute.
You think the legislature thought about divisibility on this?
Your Honor, while we don't know for certain, because use is present in the statute, these simply cannot be means, because means have to be ways of committing the same act, and uses is not the same as forged, altered, or adjusted. Furthermore, this court explained in Mathis that if a statute is indivisible and lists means, juries should be able to disagree on the action or word that was relevant and still convict. So, for example, they could disagree on with what weapon or in what location a burglary occurred and still convict. We don't have that here. The jury cannot disagree on whether Ms. Beckett forged a document or used a document and still come to the same conclusion. Therefore, using this court's framework in Mathis would indicate that this is a divisible statute. A good example of why this is a divisible statute can be seen when it's compared to the statute in Spaho, which was discussed in the lower court's opinion. That statute prohibited the delivery, manufacture, or sale of drugs, among other things. This statute is more similar to that in that it describes separate, distinct actions rather than locations or weapons.
I thought the Supreme Court, the Circuit Court, said in that particular case that possession with the intent to distribute drugs is substantially different, even though they're listed together. But that is a whole series of acts which are separated right within the framework of the statute, as opposed to listing alternative ways of how one can commit the offense which has been defined, isn't it?
However, Your Honor...
Isn't there a big difference between delivering and possess with the intent to deliver?
However, that is correct, Your Honor, that those are distinctly different things. But as we previously argued, these are distinctly different things as well because of the presence of use. Use and forges cannot be used to describe the same action. Therefore, the statute simply cannot be listing means. Furthermore, because the statute is divisible, we are able to use the modified categorical approach, which allows us to look at the plea agreement. The plea agreement also supports Section 113's divisibility because it only lists one element. Furthermore, it enumerates conduct that under both the state and federal statute would reveal a conviction.
So can I ask you about alters and adjusts?
Sure. Under the...
You respond to that. If one statute says alters and the other one says adjusts, are those the same things?
Do you mean in terms of the categorical approach?
Yes.
We would argue...
Or for that matter, it's relevant. and the modified categorical approach. Are they essentially the same thing?
Your Honor, we would argue that they are the same thing. We wouldn't draw those lines between such similar words, which is why we also wouldn't draw the line between creating unauthentic employment documents and forging employment documents. We don't believe that it's relevant to draw those distinctions between the two words. For that reason, this plea agreement does encapsulate the actions that Ms. Beckett took in the form of an element. The facts in the 14th Circuit say that Beckett was charged with forgery. The plea agreement simply states that in a different way, saying having helped create unauthentic employment letters. It is not important that the exact words match, but rather that the facts are the same. In Akinsade v. Holder, which is a Second Circuit case that considered the modified categorical approach in an immigration proceeding, it said with respect to guilty pleas, using the modified categorical approach allows a look at the facts that the defendant necessarily pleaded to determine the basis of conduct.
I actually don't understand that argument. When you are comparing the statutes, you are looking at the elements of the offense.
Correct.
Really, and the elements of the offense are defined in the statutes themselves. And when there's a different element between the federal and the state statutes, well, then there's not a match.
That is correct,
Right?
Your Honor.
And therefore, it cannot be an aggravated felony.
That is correct, Your Honor. However, what we're arguing is that the phrase helped create unauthentic employment documents is just another way of saying forge.
Okay, but you're saying, so then you're just saying that the elements are the same, because you're focusing on, not on the facts, but you're focusing on the elements, are you not?
We're focusing on the fact that the plea agreement needs to say an element, and we're saying that it's describing the element of forge. And the element of forge is in the state statute and the federal statute. Therefore, she has committed an aggravated felony. We're simply arguing that the phrase created unauthentic employment documents is synonymous with forge. Furthermore, this is increasingly relevant as if we use this Akinsade v. Holder test, which looks at the facts that were necessarily pleaded. The facts that she would have to necessarily plead to creating unauthentic employment documents are the same facts she would have to necessarily plead to forging documents. Therefore, there is no reason to draw a distinction and no reason to require that the plea agreement say the exact word if it describes the element. Lastly, this court in Mathis also said that the charging document for an indivisible statute will typically list several means because one does not need to be selected. When we look at the plea agreement here, we see one action. We do not see a list of actions like a list of locations or a list of weapons. We see one action, which further bolsters the statute's divisibility. If there are no further questions, I would urge a result in favor of the respondent tonight. Thank you.
All right, thank you very much, Ms. Stemnock. Rebuttal, Ms. Haney.
Thank you, Your Honor. I would like to address the government's position that the facts in order to plead guilty under the federal statute are necessarily the same that Ms. Beckett pled guilty to in her plea agreement. We see that she pled guilty to helping create. Helping create is not necessarily the same thing as forging. Additionally, we see that she pled guilty to having helped create employment letters. Employment letters are not something that necessarily is used as evidence of an authorized employment in the United States. Therefore, there are a multitude of factual scenarios that could lead to her plea in this situation that would not have led to a conviction under the federal statute.
Such as?
Such as saying helped creates as opposed to saying forged. If you help create something, you could provide someone with a letterhead for a company as opposed to helping actually forge that document all the way through. If there are no further questions, we would conclude by requesting that this court overturn Ms. Beckett's order for removal. Thank you.
Okay. Thank you, counsel. The case will be taken under advisement, and the court will stand in recess. Please be seated, everyone. First, all members of the improvised bench here would like to compliment all of the finalists for truly superb presentations. All four of you were excellent. That is not always the case in Moot Court Finals, but it took us a long time. And I will simply say, without disclosing too much of our deliberations, that everybody got votes, okay? So it is what we will do is announce the winners, and then we'll share a few comments and suggestions with each of you, and then everyone will be free to head on to whatever entertainment is available. So the two winners of the Minton Moot Court Award competition this year are Carolyn Haney and Alex Van Dyke. And now comes the painful part, with comments.
You're going to start with me, okay.
Yeah, we're going to start with Judge Pyle.
Let's see. They'll be very brief. Ms. Murphy, I thought you had good voice, good eye contact. That's very important. Good knowledge of case law to make your points. You stuck to the facts. In fact, actually, you corrected one of the judges, right? I mean, that's good. Mr. Van Dyke, again, good voice, good volume, good eye contact. Again, good knowledge of the facts. You all had really good knowledge of the facts. And I liked how you used the case. You mentioned the particular case and a couple of other cases to make points, and you actually knew the facts of those cases and the holding. I thought that was great. Ms. Haney, again, great eye contact, good knowledge of the facts. And as an appellate court judge, when you end early, that's automatic points. All of us have, sometimes attorneys sit up there and they just keep talking. You're like, we've already said that. And it's like, sit down. I mean, if you're done. Outstanding. You emphasized, hey, if nobody has any other questions, I'm finished. And that's great. Let's see what else we have here. Ms. Stemnock, again, great volume, good eye contact. Got a little flustered there, but you know what? I thought it was great because you still kept rolling. I threw these guys. You had this prepared argument. What was the first words?
Opening. What was it? Since the
history of
since the advent of the criminal justice
I was like, nah, we're shutting that down. But I wanted to see how you'd handle it, and you handled it. You went on. I threw a joke in later on at the end. Everybody started laughing. You actually laughed with me and kept rolling. Mm-hmm. That's great. You did not stop. You kept on with your argument. Great. And then you also ended early, I think, on yours. When you finished, it's okay to stop. There is no award for length of argument. When you're done, you're done. That's all I have.
Well, I echo Justice Hamilton's comments at the beginning, which is that all four of you did a terrific job. I mean, I've been a judge the least long of those of us up here who do that for a living. And in the probably 70 or 80 oral arguments that I've heard on my court, on the Indiana Supreme Court, all four of you were as good as, or in some cases better than, many of the advocates who come before us. So the caliber of the advocacy has just been excellent. I'll make a few individual comments. Ms. Murphy, I share Judge Pyle's view. Poised, nice present. I thought you had a really nice delivery. You were confident. You showed a great deal of I thought you handled a lot of, in many cases, difficult questions well. A couple of occasions throughout the argument, you threw in, I believe, it's my opinion that, and Judge Hamilton got you on that, which is a fair observation, but it's a minor detail. It really doesn't detract from what overall was a really nice performance. I commend you for a good job. Mr. Van Dyke, you began with a really nice roadmap. I thought you did a particularly effective job of using precedent, of not only reciting ably what the precedent stood for, but applying it well. in response to a series of questions from the bench. I thought you answered them well and then transitioned back nicely to your own points. You stuck on script, which was very effective. You began to get a little bit derailed at the issue of objective versus subjective, and you I think appropriately recognized, I'm not sure I want to go there, and recognized that probably need to retrace my steps a little bit, and I thought you bounced back nicely, but I thought you did a very nice job as well. Ms. Haney, I thought you did a nice job. Let's see. Sorry, I'm having problems reading my own notes here. Forgive me. You really negotiated this, what for me is not a federal judge who's accustomed to dealing with the sentencing issues and tracking what a state sentence means for federal purposes and whether aggravation is warranted. This for me was a conceptual morass, and I frankly, having tried to sort through Justice Kagan's opinion, I'm not sure I'm any better equipped after having read it twice than beforehand. And I thought you did an especially effective job of kind of plotting through that, working through that, and did an especially nice job of making your points, and I think persuaded me at the end of the day. It has already been mentioned, Ms. Stemnock, you opened with I think you're the only one who wasn't really able to get a few lines out before you were interrupted right out of the box, and one certainly could imagine having been flustered under those circumstances. And I thought you really stood up especially well. I thought you were very effective. Let's see, one other thing I wanted to point out. This is a small point, but when you're going to be relying on language from the sentencing judgment, boy, it's really valuable. It's important to have that, whether it's the document itself or something in your notes that you can actually read from. It gives not just the appearance, but the reality that there's something here that, let me answer your question, Your Honor, and I'm actually reading from page 93 of the record, and here's what it says, and it gives instant credibility, and you're in a position to answer the question right away. Again, it's a small detail, but that's just a minor point. But on balance, I thought you also did a very nice job.
Okay. I generally agree with everything else that my colleagues have said specifically. Let's see, Ms. Murphy, very poised. You have the challenge of going right off the bat and trying to figure out how hot is this bench going to be? How am I going to cope with that? You'd handle that very well. I did pick on you on the in my opinion, and I'll tell you why I did that. Because in constitutional law in particular, and with the kind of argument you wanted to make, which is overrule this precedent because circumstances are different than they were a generation ago, the danger of kind of drifting off into personal opinion and anecdote is great. And that's true just in that area of the law, and that's why I wanted to bring you back and kind of give you a jolt like that. Which you handled well, and you recovered, and you didn't do it again, and carried forward with your argument. Your handling of the racial profiling question, I thought was excellent. About national characteristics, yeah, that's okay, but there are limits, and you've got to prevent that. I thought that was a really critical point, and your rebuttal reinforced your central points. Mr. Van Dyke, you came across as almost too reasonable. I was kind of knowing we don't know the problem as well as you all do, but I was surprised and interested, and you may explain it later, why you chose to go ahead and agree that there is an egregiousness exception when all you've got is a four-person concurrence. Just saying that's never been applied. Maybe it's out there somewhere, never been applied by the Supreme Court. But it certainly protected you from some of the most difficult questions we might have wanted to ask you. So you handled Michigan against Summers very well on the detention. of people. You did get a little lost in response to the subjective, objective question, that series of questions that I was asking you, but I agree you recovered. And I will say I was dazzled when you pointed out that 1983 did not provide an effective remedy at the time Map against Ohio was decided. That's legal history going back almost 60 years. Very impressive. Close was a little abrupt, but that happens with your red light. Ms. Haney, I'm going to draw on gymnastics. When you were going through your divisibility maneuvers, I was writing, she sticks the landing, okay? This was, I was dazzled, okay? It is tricky stuff, as all of us have learned to one degree or another, and I thought you had it very well in trying to at least sort out the strongest argument on your side, and again, great manner, eye contact, poise. And then finally, Ms. Stemnock, the term of imprisonment, it's a problem for you, at least. I don't know, did it change from the early rounds to the final rounds?
It got added for
Okay.
the later arguments.
Okay, which suddenly gives you a really tough problem to deal with, right? So, and you did the best you could, you handled it, and when you were ready to switch gears, you switched, okay? It was a little sudden in your pivot to divisibility, but it was very firm. You wanted to go there, you knew you didn't want to stay where you were. Great. And your point about the jury being able to disagree on some of the particular points within the statute was excellent. That's a really critical analytic maneuver in this area, and you did it concisely and persuasively. And I will stop there except to say again, all four of you, I hope from all these comments you can hear why this was so difficult for us in these choices.
Well, I mean, I agree with everything that's been said. I thought the four of you just were phenomenal. I thought you did an extraordinary job. We who are judges on a daily basis watch a lot of lawyers, and I will tell you that your approach and your professionalism matched a large percentage of the lawyers we see in our courts. So you should really be proud. And the fact that you had tremendous grasp over some very complex issues, I think, was pretty extraordinary. So let me just go quickly, individually. Ms. Murphy, I thought your demeanor was excellent. You looked people in the eye. You did not appear to be distracted in any way, even though the questions started to come at you. And I thought you showed a level of confidence as if you've been here before. And I really appreciated that. The interesting thing I thought was that you didn't use the language that Justice O'Connor used. And in fact, that's probably a general observation. I think the more precise you can be in using the language, the better. In fact, you gave up widespread. And that was an interesting question as to whether widespread would go forward. You basically never mentioned it. And I assume from that you waived that argument. Ordinarily, if you're not going to waive an argument, you need to say something, and then it won't be waived. But in egregious, I thought you had an excellent analysis of egregious. Mr. Van Dyke, I thought you seemed very calm. Have you done this before? Or? I thought you had an excellent argument. I want to say that I was shocked that you gave up on striking the exclusionary rule. Remember, if you're basing your argument on egregiousness and widespread, it really is almost an dicta afterthought by Justice O'Connor and has been latched upon by other courts. I'm not so sure justifiably. It is dicta. And I'd be shocked if the Attorney General would have been happy about you waiving the application of the exclusionary rule in these kinds of cases. Maybe he would have. I mean, his name is Sessions. It's a good name. But I'd be a little shocked if all of a sudden you by doing that, are inviting a debate every time you have a deportation hearing. So, Ms. Haney, again, you, I thought, had a really good grasp. This goes to show something about the complexity of the issue, right? So David and I, Judge Hamilton and I, both federal judges, and we had a different assessment of whether you had a good grasp on it. He thought you were right on point, and I thought you slipped a couple of times, and so he deals on the Seventh Circuit with this issue all the time, and I was on the Sentencing Commission for years, and we had to deal with this divisibility and indivisibility, which makes absolutely no sense. It comes out of Justice Kagan's opinion, and it is very difficult to apply, but you did so very confidently. The only criticism I'd have is in your rebuttal. There always are things which are raised on argument on the other side, and it's just important that you listen carefully to what is being argued, and then you develop a response. You sort of passed on that, and that probably would be my one, general criticism. One of the things that, at least I've observed in court, is that lawyers don't listen enough, and you haven't prepared this in advance, but you got to listen and you've got to move. And what's interesting about trial work is that really, it's just a moving target. It's a constant moving target. So all of a sudden, they've raised another question. Well, and you've got to respond to that, and you've got to be ready for that, which means you have to keep your mind open and flexible. And again, Ms. Nemrock, I thought you were very confident. You looked us right in the eye. There's no question that you felt confident, and you argued eloquently. I thought it was superb.
So I don't have too much to add in addition. I agree with what my fellow judges, it's kind of nice to say that, for this fleeting moment, have said. I thought you all did an incredible job, and I have great empathy for being on that side. Not that I've ever actually been on that side, but I've been in support of people who've been on that side, and I know that it takes an incredible amount of work to be as good as you all were tonight. So kudos for that. Just a couple of comments. So, Ms. Murphy, I just really admired how you stood your ground, and when you needed to go to your next point, you did so, but you've always answered, and you answered promptly and confidently, which was impressive. Mr. Van Dyke, you had lots of tough questioning, and you, again, as others have said, you were calm and measured and didn't roll your eyes when I had a stupid question. Or, none of them had stupid questions. But, Ms. Haney, you, as others have said, they knew this puzzle. I have to admit, this problem. I have to admit, when I read this, I thought, "Oh my God!" And Professor Lon asked me to do this, and he's never going to get to hear the end of it. But you were incredible at clearly explaining a puzzle, so that was really admirable. Ms. Stimnuck, you did a great job, and you were confident and sure in your position, and I will say that based on your previous experience with the ACLU, I know that you couldn't have meant all the things that you said. But you were quite convincing, So, congratulations to all of you.
just want to say thanks once again to all of our judges for being here tonight, and to our competitors. Again, an incredible round of argumentation. It was really a treat to watch. So thank you guys.